Good afternoon, everyone, and thanks for joining us for our webinar, which is part of our regular construction law updates. My name is James Vernon, and I'm a partner at Beale Co. I'm joined by Madeleine Kelly, and together we are part of our construction group, providing non-contentious and contentious advice for the construction, engineering, and infrastructure industry. This webinar is a follow-up to our earlier webinar at the end of March on the contractual implications of Covid-19. Since that webinar, the situation with Covid-19 has moved on and is ever evolving, including government and advisory body guidance and advice to assist in the effort to restrict the spread of coronavirus and return to normal, or the new version of normal, as quickly and safely as possible. Our aim is to give our take on those future steps for the construction sector from a contractual and practical perspective. The focus is on construction contracts and steps for contractors and subcontractors to take. However, the advice is relevant for those construction professionals involved in the management and administration of construction contracts. We have over 550 people signed up to attend today, and we hope you find this webinar informative. Looking at the agenda, we'll first cover the current government and industry guidance and advice, which puts into context the future management of construction projects and feeds into what we consider are the three broad scenarios for live projects. Those where work has stopped pursuant to a suspension or other contractual notice issued by either the contractor or the employer. Those where works have stopped on an informal collaborative basis between the contractor and the employer, and those where work is still continuing. I will then discuss some practical measures that can be taken for projects that have been suspended or are likely to be suspended. Madeleine will then consider the contractual position regarding first notices and ongoing notice under the major standard form contracts, JCT, NEC 3 and 4, and FIDIC. These notices are vital to protect your entitlement to recover time and or money, or to mitigate against any future claims by employers. Madeleine will also discuss the contractual processes under those standard forms in order to restart on site, either as a result of a relaxation in the current social distancing requirements or following an assessment that it is safe to resume on particular projects. This will include ensuring payment procedures are brought back online as quickly as possible to protect cash flow, together with entitlement to remobilisation costs. I will then look at some practical issues to address when restarting on site, including those steps that can be taken in advance. Of course, the current guidance the industry is receiving is always developing. It may be that in the coming days and weeks, what is considered to be a sensible approach now may not be so, and as I'm sure all are doing, checks need to be made of the guidance and advice that is being produced daily. As from our earlier webinar, we are delivering this from an English and common law perspective, although many of the principles we discussed today are equally applicable in jurisdictions across the world, in particular the practical and collaborative steps that can be taken. In addition, our offices in Ireland and the Middle East have been producing their own specific advices and webinars, which are available on our website. The lockdown has been with us for just over 3 weeks now. In that time, the information published by the government and leading industry bodies, including the Construction Leadership Council and Build UK, has focused on the balance between ensuring safety of employees and the public to assist in restricting the spread of the pandemic, with keeping sites open and the industry contributing to the economy where feasible and safe. The starting point is the government advice on social distancing, as this has fed into how sites can operate safely, and where they cannot, has necessitated steps to suspend works and close down sites. What has been important is the government's understanding that industries such as construction require their own specific guidance to safely maintain the provision of services, particularly public services. The government's position is that site work can carry on in accordance with the social distancing guidelines wherever possible. The phrase wherever possible has caused some uncertainty in considering the degree to which works can continue, even when social distancing guidance can't be met. But our advice has been that ongoing works must be carried out in a way that is compliant with the current government and industry advice and safeguards your employees' health and safety. The onus remains on site operators to carry out risk assessments, taking into account the type of work, location of workforce, supplies needed, and other factors when deciding whether or not to remain open. The government advises that if social distancing guidelines cannot be followed in full in relation to a particular activity, consideration should be given as to whether that activity needs to continue for the site to continue to operate. And if so, the parties should take all mitigating actions possible to reduce the risk of transmission. If you consider that those mitigating factors do not address the risks to your employees, or you can't comply with such factors, then you should seek advice as to your contractual rights to stop work arising from health and safety issues, as the right to suspend may not necessarily be triggered. The government has advised what should be done on site to restrict the spread of coronavirus, including keeping 2 meters apart, and this has been developed by the industry bodies. Even where sites remain open, there will be ramifications, including it's likely that with a reduced workforce or spread out workforce, the work will take longer, and it will potentially cost more. There will also be the need to provide additional hygiene stations on site to ease the spread of the coronavirus. Given that there will be difficulties on site, this forms the need to ensure ongoing contractual notices and processes are followed and accurate records are kept so that the cost and programme implications specific to coronavirus can be identified as being separate to any pre-existing delay or cost issues on a project. As I said, to assist the industry interpret the government guidance, the CLC and Beale UK have produced various documents. They've produced an advice on the temporary suspension of sites, which provides guidance on steps to be taken if government measures cannot be followed. This is dated 30 March and includes advice on close down measures, site safety, security, and steps to take to protect your contractual position. Secondly, Beale UK and the CLC have published guidance on site operating procedures in order to protect the workforce where work continues. As is the way when preparing a webinar, this was reissued this morning, and so this is the latest guidance we've received. This stresses that construction sites operating during the pandemic need to ensure they are protecting their workforce and minimising the risk of the spread of infection. This includes considering how personnel travel to and from the site. Their guidance is based on central government, Public Health England's central guidance that the social distancing should be followed, and if it cannot, you should consider whether that activity should continue. It's important that the health and safety requirements of any construction activity must not be compromised at this time. If an activity cannot be undertaken safely, it should not take place. The guidance, however, does allow closer than 2 meters working in special circumstances, and as you'll see on the slide, it's based on a hierarchy of controls: eliminate, reduce, isolate, control, PPE, and behaviours. A due guidance has been given, and so why certain sites are continuing to open. In this regard, you may consider it sensible to put together a description of the project, for example, if it's considered to be critical or essential works, and also a statement that confirms and links to the safe working practices adopted for the site that is in line with government guidance. And this should assist in avoiding any negative press that may occur. Finally, for this introductory section, for all 3 broad scenarios, there is the role of the design and consultant teams. Those teams will be mainly working remotely, as their presence on site is not likely to be considered essential. As such, there will need to be management of their ongoing role and maintenance of communication with them. And some of these points at the bottom of the slide relating to RFIs and work that can be done, we'll discuss in more detail later under the practical steps, but we reiterate, good communication with your design team is important at this time. So turning to the measures to be taken and issues arising during site closures, or if your site faces site closures in the near future. Obviously, sites operating now still might have to close down. For example, if works that can be done in accordance with the guidelines are close to complete, but any remaining works cannot be done safely, then that site will need to be shut down. And there are a number of practical steps that should be taken to both safeguard your position as to the status of the work at the point of close down, which will enable consideration of programme and payment entitlements, but also to enable a smooth transition when the site reopens. It should also be noted that it's possible that some of the steps I go on to describe will require a site present once the site is closed. And so we would recommend an appropriate separate risk assessment is carried out for that site attendance, that the visit is done by as few as possible, preferably only one person, and that the site owner or employer is advised that there will be someone on site so as to avoid any unnecessary contact. Firstly, and as reiterated in our webinar of a few weeks ago, all measures should be considered in the context of your contract. Make sure that key contractual information required, for example, for input into the programme, is recorded. It is fully important to understand the status of your work at the point in time the site closes. This will assist in understanding the work done and to be done once the site reopens, in order to be able to properly adjust programmes and consider what entitlements to additional time and potentially loss and expense existed before the impact of coronavirus was felt. It will also benefit planning the key work to undertake once sites reopen, whether they be necessary in order to get the site up and running, or are works that go to the heart of the critical path and so should be focused on rather than any peripheral work. This will also assist identifying any acceleration measures that could be proposed once sites reopen. Obviously, leaving a site does have serious consequences. A detailed site survey will identify what areas of the works need protecting during the close down. For example, is plants such as scaffolding safe and secure? And can the location on site be identified of any plant? A vital part of this will be for projects in the early stages where elements of existing properties may be propped or temporary works carried out, or there's areas exposed. Once those are identified, proposals can be considered with the site owner to make these items secure, with such work carried out to secure it being compliant with government guidance. This 0-point assessment can then be updated as considered applicable during the period of lockdown and then once you restart. It also goes hand in hand with ensuring adequate site security is in place during the period of closure. And there is no doubt that site closures will lengthen the programme and so the time for compliance with contractual obligations, and this will include providing and maintaining insurance policies. While professional indemnity and ELPL insurances are annual, there may also be requirements under the contract for project-specific insurances. Those policies are inextricably linked to the programme, and so steps must be put in place to ensure necessary extensions are obtained. It may be that the policy has a long life because the close down is at an early stage, but nevertheless, the need to potentially extend the policy is one that should be raised with the party responsible for taking out and maintaining the policy. Further, given that sites will be empty during the close down, notwithstanding the security measures in place, we consider it prudent to notify insurers of any close down, and this would include PL insurers regarding potential liability to public injury caused on an empty site. And as Madeleine will explain in a moment, contractual obligations regarding notices should still be followed. We've also seen over the last few weeks clients taking proactive steps during close down in order to identify work that can continue. Indeed, reports from the Far East, where they've had coronavirus earlier, have emphasised that continuing with design and office work as much as possible has aided the restart process once restrictions are lifted. This will include working with your design team in order to finalise elements of the design that are in abeyance, and where plausible, work on future stages before the programme design delivery date. Early finalisation of these designs will enable you to hit the ground running once sites are reopened, as well as identifying programme savings that could mitigate the overall effect of the pandemic on the project. Working with the client and the key design team members could also assist in identifying alternatives and savings, which many clients will find important, given the uncertainty as to the overall impact coronavirus will have on the economy. The design team can also be worked in conjunction with the contractor to deal with any outstanding design queries and request further information, such that what is to be built is as finalised as possible. This will also impact on any necessary approvals and permissions, including planning. By working with the design team, you can ensure that the resource allocated to the project reflects what is needed from them. This may necessitate notices of suspension or hold notices for their services, but good communication will enable a smooth transition, both from active sites to close down and then from close down to reopening. Finally, a key part is maintaining relationships with your supply chain, as they will be key once sites reopen. This will include identifying who has stock, what are their delivery procedures, what have they got in place to be able to increase either obtaining products or making products such that an increased demand can be met. There will be a lag, and careful management now of those suppliers may help mitigate the effects of demand outstripping supply. Over to Madeleine.
Thanks, James. In this section of the webinar, I'm going to discuss firstly the extent to which you may be able to rely on COVID-19 and its effects constituting an event of force majeure, both contractually and at common law, including other common law alternatives. And then I will discuss the first and ongoing notices in relation to claiming an entitlement to additional costs during the suspension period as required under the standard forms JCT, NEC3 and NEC4 ECC contracts and the FIDIC Red, Yellow and Silver books, which I will also refer to as the Rainbow Suite. And lastly, James will take you through the scenario where there are no notices provided in your bespoke contract, or where the parties have not been following the notices and the alternative avenues available to you if there are no notices to be issued under the contract. The key question in terms of COVID-19 for contractors is, what is your entitlement to relief? Are you entitled to an extension of time? Are you entitled to payment of any loss and expense? Firstly, turning to claiming relief under the concept of force majeure. As set out in the previous webinar, force majeure is effectively a civil law concept and it is not recognised in common law, i.e. UK law. Therefore, the term is only recognised and given legal effect in the UK when written into a contract. A force majeure clause typically excuses one or both parties from performance of the contract in some way following the occurrence of certain events. Its underlying principle is that on the occurrence of certain events, which are outside a party's control, that party is excused from or entitled to suspend performance of all or part of its obligations. Although the term varies widely between standard form contracts, we believe that COVID-19 is likely to constitute a force majeure event. Turning to the standard forms under the FIDIC 1999 and 2017 Rainbow Suite, both versions contain very detailed force majeure provisions. If we look at clause 19 of the 1999 Red Book, for example, whilst it does not list disease or epidemic as a force majeure event, it defines a force majeure event as one which is beyond a party's control, which such party could not reasonably have provided against before entering into the contract, which a party could not have reasonably avoided or overcome, and which is substantially attributable to the other party. As such, we think that you will be able to claim COVID-19 as a force majeure event and will be entitled to an extension of time for any delay by reason of COVID-19, although not to payment of additional cost. The NEC3 and NEC4 ECC contracts take a similar approach in defining a force majeure event, but refers to the term prevention in clause 19. However, unlike FIDIC, the NEC contracts do not state the effect of prevention on the parties, including whether additional time or cost is to be awarded. This comes under the compensation events procedure. Although not a defined term in the JCT contracts, force majeure is recognised as a relevant event. For example, if you look at clause 2.29.15 of the JCT Standard Building Contract with Quantities 2016, the term is not a relevant matter, and therefore you will only be entitled to an extension of time, but not to payment of loss and expense. However, note that if there is no force majeure provision, then you may have to rely on the common law doctrines of prevention and frustration. Firstly, one common law doctrine is prevention. As discussed in the last webinar, prevention can only be used as a defence to a client's claim, example for liquidated damages. In addition, prevention will only entitle you to an extension of time and not to additional costs. Prevention occurs where, for example, your employer causes delay and therefore prevents you from performing your obligations in the time required by your contract. Then your employer cannot enforce the contractual timescales against you, as you've been prevented from meeting these timescales. This may be relevant if your employer has closed the site or where they have imposed restrictions on the way you work, which will cause delay. Secondly, another common law doctrine is frustration, which is relevant when there is a more fundamental issue with the performance of the contract. That is, where a supervening event occurs after a contract has been agreed, which is neither party's fault and which goes to the root of the contract, essentially rendering the performance of the contract impossible, illegal, or even unjust. Frustration is a drastic remedy and seeks to bring your contract to an end. However, note that frustration is rarely implemented, although a claim on frustration could be brought if the UK government, for example, were to order the closure of all construction sites, and therefore non-mandatory government guidance would not apply to frustration. The standard form construction contracts, including the FIDIC Rainbow Suite, the NEC3 and NEC4 ECC and JCT contracts, are very procedural in terms of claiming entitlement and include early warnings to be made, which we discussed at length in the last webinar and which we'll not repeat today. After the warnings have been given, the next contractual mechanism that we will look at in terms of suspension to the works and making claims is issuing first notices for delay and additional costs. Firstly, turning to the FIDIC Rainbow Suite, this form of contract contains very prescriptive wording in relation to contractors' claims. For example, clause 20.1 of the 1999 Red Book provides that if the contractor considers itself to be entitled to any extension to the time for completion and/or any additional payment as a result, the contractor shall give notice to the engineer describing the event or circumstance giving rise to the claim. However, note that FIDIC imposes a time limitation of 28 days during which notices need to be brought from the date in which the contractor became aware or should have become aware of the event or circumstance causing delay. Crucially, the consequences of failing to give notice when you should will be serious, as clause 20.1 provides that failure to comply with this time period will mean that the contractor shall neither be entitled to an extension to the time for completion, nor shall it be entitled to additional payment. An employer shall be discharged from all liability in connection with the claim. There are also additional requirements to be followed once a claim has been made. Turning to the NEC3 and NEC4 ECC contracts, they require notices to be given for compensation events. For example, clause 61.3 provides that the contractor notifies the project manager of an event which has happened or which the contractor expects to happen as a compensation event if the contractor believes that the event is a compensation event and the project manager has not notified the event to the contractor. Unlike the FIDIC suite of contracts, the NEC compensation event provisions require that you give notice once there is an event that has happened or is expected to happen, which you believe is a compensation event. The most likely compensation event will be prevention under clause 60.1(19). If accepted, you will be asked to submit a quotation which will require a forecast of the time and cost implications. These will be difficult to ascertain at this time given the relatively early stages of the lockdown and uncertainty as to future guidance from the government. As such, where possible, any quotation should be based on agreed assumptions with the project manager, who should be asked to confirm those assumptions so they can be revisited. In this regard, collaboration with the project manager on COVID-19 events will be very important on NEC projects. As a result, it is vital that you notify COVID-19 as a compensation event under your NEC contracts now, rather than later. Similar to the FIDIC suite of contracts, there's a severe sanction prescribed in the NEC 3 and NEC 4 ECC contracts for failing to comply with the compensation regime. Clause 61.3 provides that if the contractor fails to notify a compensation event within 8 weeks of becoming aware of an event, the contractor, subject to very few exceptions, loses its entitlement to adjustment of the prices, the completion date, or any key date. In dealing with notifying an entitlement to an extension of time, an additional cost, the JCT Standard Building Contract with Quantities 2016 deals with these two issues separately. Firstly, clause 2.27.1 deals with providing a notice of delay. This essentially sets out that when it becomes reasonably apparent to the contractor that the works or any section of the works is being or is likely to be delayed, the contractor shall immediately notify the architect or contract administrator of the material circumstances, including the causes of delay, and shall identify in the notice any event which is in its opinion a relevant event. Secondly, clause 4.2.1 deals with notices in respect of loss and expense, requiring that the contractor shall notify the architect or contract administrator as soon as the likely effect of a relevant matter on regular progress becomes reasonably apparent to the contractor. There are then further requirements to provide updates. Note that the JCT notice mechanism doesn't prescribe a sanction for failing to give notice. It also doesn't specify long stop timeframes for notices. Clearly, this is a positive for contractors, but it should not be taken as a reason to fail to give a notice. Once the project has been suspended and your first notices have been issued in respect of delay and additional costs, the standard form contracts include additional ongoing requirements to update and notify the contract administrator, engineer, or project manager as to site progress, the programme, the budget, or other matters. Although generally speaking, there are no express sanctions attached to failing to comply with these update notifications, failing to do so would of course put you in breach of your contract, and therefore such a breach could be used against you by an employer seeking to withhold payment or additional costs or to deny you an extension of time. We therefore strongly advise that you continue to comply with the update requirements under your contracts, even after suspension has been initiated. Turning to specific examples in the standard forms, we'll first turn to the FIDIC Rainbow Suite. Clause 8.3 of the 1999 FIDIC Red Book requires revised programmes to be issued whenever actual progress is inconsistent with the contractor's obligations. Therefore, any delays to progress of the works will trigger these update requirements, including when you're back on site and the site is not in the condition that you left it, example where apparatus has blown over. Note that FIDIC also requires submission of monthly progress reports that are very detailed and prescriptive, requiring, amongst others, submission of progress charts, site photographs, safety statistics, and many others. In addition, as mentioned in relation to first notices for extension of time and additional payment, if the delay and additional costs incurred continue to prolong, Clause 20.1 provides for the contractor to issue further interim claims at monthly intervals, giving the accumulated delay an claimed, and further particulars as engineer may require. In addition, 4.21 of the 1999 FIDIC Red Book provides that the contractor must provide monthly progress reports. This appears to be condition precedent to payment pursuant to subclause 14.3 that requires submission of the progress reports as part of the contractor's application for payment. As just mentioned, progress reports must include, amongst others, progress charts, site photographs, and safety statistics. Accordingly, the impact of COVID-19 on the progress of the reports must also be accounted for in these reports. With respect to the NEC3 and NEC4 ECC form of contracts, Clause 32.2 also requires revised programs to be submitted periodically and at time intervals stated in the contract data. However, the NEC provisions are a lot less prescriptive than the FIDIC provisions. Although note that the NEC form of contract does require updates in the form of statements of actual progress and the effects of compensation events, how the contractor intends to deal with delays, and any other changes proposed to the programme. It is therefore important that you take into account the effects of COVID-19 when you issue these programmes, as progress is likely to be delayed due to safety measures being put in place and restrictions on the number of personnel allowed on site at any one time. This is likely to have a huge impact on the timescales for completion of works, and therefore the programmes need to be carefully revised accordingly. On NEC projects, we advise that you keep the accepted programme up to date, as this is the benchmark against which assessment for a compensation event is made. If there has been a delay and your programme is not up to date, your assessment for a compensation event will be based on an out-of-date version, and therefore you will not get the extension of time you require. The JCT is not as prescriptive as the FIDIC and NEC form of contract in respect of ongoing notices. They do not contain standalone update requirements, and there is no programme drafting. Rather, update requirements are triggered by notices of delay. Clause 2.27.3 of the JCT Standard Building Contract with Quantities 2016 provides that the contractor must immediately notify the architect or contract administrator of any material change in the estimated delay or other further particulars required by the architect or contract administrator. In relation to ongoing notices for increased preliminary costs and other costs, the standard forms also contain similar update provisions. Firstly, with reference to the FIDIC Rainbow Suite of contracts, as provided in Clause 20.1 of the FIDIC Red Book 1999, if the circumstances warrant a continuation of an extension of time or an increase in additional costs, there is an ongoing requirement for the contractor to, amongst other things, send further interim claims at monthly intervals, giving the accumulated delay or amount being claimed, and such particulars as the engineer may require for assessment and approval. Whilst the NEC ECC also deals with notifying time and cost together at the time the compensation event is notified, or shortly after, as discussed in respective quotations, the JCT deals with ongoing notices of loss and expense separately. Clause 4.21 of the JCT Standard Building Contract with Quantities 2016 provides that the contractor shall notify the architect or contract administrator as soon as the likely effect of a relevant matter on regular progress or the likely nature and extent of any loss or expense becomes reasonably apparent. The contractor shall continue to update the architect or contract administrator at monthly intervals until all information reasonably necessary to allow ascertainment of the amount of loss and expense has been supplied.
Thanks, Madeleine. There are situations, particularly on smaller sites, where contractors have taken steps to withdraw from the site, either unilaterally or with agreement from the employer, but have not issued any necessary notice regarding suspension. Alongside this will be bespoke contracts where steps required in situations we are currently facing are not set out. Should this be the position, then we advise seeking legal advice as soon as possible so that the necessary steps under your contract can be reviewed and steps taken to avoid any future issue by having withdrawn from site in this way. Of course, if the withdrawal has been done with the employer's consent, then the situation may be easier. It should be possible to agree a site letter or a variation covering the period of site closure, such that the parties' positions are understood and recorded. In simple terms, this would cover no entitlement of the employer to claim liquidated damages during any period directly attributable to the close down, possibly subject to a condition of a prompt restart with a new programme submitted, and an allowance for a reasonable sum for any additional costs that would be associated with the close down and remobilisation. An alternative is to seek a without prejudice agreement as to the position to allow for a negotiation. If works have stopped without notice and without the employer's consent, there may be the need for a more direct negotiation route. And at the outset, we repeat our advice that should be done on a without prejudice basis in order to facilitate a deal. If the above earlier advice is taken on board regarding a detailed risk assessment as to why works on site cannot continue given the government guidance, and that there is an accurate record on progress as at the date of close down, your position is likely to be strengthened should the employer challenge your actions. Madeleine.
We are now going to discuss the impact of recommencement of the works and essentially redressing the balance, including what are the correct contractual notices to restart the works, and the factors to consider in restarting the payment process. James is then going to conclude with the practical issues to consider. We will first look at when restrictions on site have been lifted and when the employer wants to resume the works, or when the contractor considers that based on a risk assessment of the works that these can be resumed safely and in accordance with government and CLC guidance. We will look at how this is done under the standard forms, including how remobilisation costs are dealt with. Firstly, in terms of recommencing the works, the 1999 FIDIC Red Book, Clause 8.1.2 and Clause 8.13 of the 2017 version provides that the engineer may notify the contractor to resume work, and the 2017 version further adds that the contractor must resume work as soon as practicable after receipt of the notice to do so. Importantly, if on receipt of such a notice you consider that you cannot comply with the government and industry guidance and advice in restarting the works, you must seek advice as to your position under the contract to see if any challenge can be made or if a counter notice can be issued in response to the engineer's notice to resume work. The FIDIC Red Book also provides that upon instruction or notice to proceed with resumption of the works, the engineer and contractor are to examine jointly the works and plant and materials affected by the suspension. The contractor is then promptly to make good such matters so that on completion such matters will comply with the contract. To the extent that any such deterioration, loss, etc. is not due to the contractor's failure to protect, store or secure the materials in accordance with Clause 8.9, the contractor may be able to claim an extension of time or additional payment, example where the damage is attributable to the employer, engineer or another contractor on site. As for the NEC 3 and NEC 4 ECC forms of contract, Clause 34.1 provides that resumption of the works will be upon instruction from the project manager, as the project manager may instruct the contractor to stop or not start any work and will subsequently give an instruction to restart or start the works. The issue regarding whether the works can be restarted safely is the same as under the FIDIC forms, i.e. you will need to seek advice on what basis you can bring a challenge to the project manager's instruction to resuming the works. The JCT does not expressly deal with resumption of the works. Instead, it would appear that resumption of the works would be by way of instruction from the architect or contract administrator in accordance with clause 310 of the contract. Under these standard form contracts, although the notice to restart does not come from the contractor, there is nothing to stop the contractor from requesting such a notice should it be issued, provided that the contractor has carried out a risk assessment to ascertain that the works can be carried out safely. Turning to how the standard form contracts deal with claiming an entitlement to remobilisation costs, Clause 8.9 of the FIDIC Red Book 1999 provides that if the contractor has had to suspend works under an instruction of the engineer and incurs cost as a result, the contractor shall give notice to the engineer and shall be entitled to, subject to complying with the notice requirements in Clause 20.1, payment of any such cost provided that the cause for suspension was not due to the contractor's fault. As previously discussed, Clause 20.1 provides for a notice to be given within 28 days after becoming aware of the event or circumstance, and therefore it is important that you notify your claim as soon as possible. In respect of the NEC, ECC, and the JCT forms of contract, these do not expressly deal with remobilisation costs. Looking at the NEC3 and NEC4 ECC forms, it could be argued that a compensation event arises pursuant to clause 60.14 by an instruction to stop work with the associated cost of restarting to be included in the quotation. Likewise, in relation to the JCT, it could also be argued that the contractor is entitled to remobilisation costs pursuant to clause 4.22 of the JCT Standard Building Contract with Quantities 2016, which deals with relevant matters arising from an impediment or prevention by the employer. Now we will look at how the standard forms deal with restarting the payment processes with employers. With reference to the 1999 FIDIC Red Book, Clause 14.4 provides that instalments due under a payment schedule will be defined by reference to actual progress achieved in the execution of the works. However, if actual progress is found by the engineer to differ from the schedule on which payments are based, the engineer may proceed under Clause 3.5 to agree or determine revised instalments in order to reflect the extent to which progress has been made. In the absence of a schedule of payments, the contractor is to do a degree of forward planning, in that it is to submit non-binding estimates of the payments which it expects to become due during each 3-month period. Note that you will need to also have adequate records of payment. In respect of where to send notices, this may have changed by the time the site is up and running again, and therefore, referring to clause 1.3 of the Red Book, the contractor is to submit payment applications to the address stated in the appendix to tender or as otherwise notified by the engineer. Again, the NEC ECC form of contract and the JCT Standard Building Contract with Quantities 2016 do not expressly deal with the restarting of the payment process. However, any amendments to the payment schedule in relation to the NEC ECC form is likely to be via a variation to the contract in accordance with clause 12.3, and the payment applications are to be submitted to the address notified in accordance with clause 13.2. In relation to the JCT, any amendments to the payment process are likely to be an instruction by the architect or contract administrator under clause 3.10, and the address to which payment applications are to be submitted will be the address notified to the contractor, or where different from that stated in the contract particulars in accordance with clause 1.7. If you have employed subcontractors, you will need to review your subcontracts and amend the payment processes in accordance with those upstream. Note that there are many other points to consider in restarting the works, which we have not mentioned today. However, briefly, a few are: you will need to consider notifying further updates to the programme and cost plan. You may also be required to engage in an accelerated programme, for example, under Clause 36 of the NEC ECC form of contract. Given the many considerations arising from the impact of COVID-19 on the progress of works, we are seeing clients coming to us for advice on their contractual position when either notices are being issued to them to restart the works, or where our clients themselves consider notices should be issued to restart the works. In particular, we are being asked by our clients to advise them on how to ensure correct steps are taken to safeguard any entitlement to time and money, and at the same time, how to protect the health and safety of their employees by ensuring the government and industry guidance can be complied with.
Thanks, Madeleine. That is the contractual position. We're now going to look at some more practical issues for restarting on site. And that restarting on site might be a full or partial remobilisation, depending on the works that can be done. As above, some of the steps may have been taken in anticipation of a restart. The more you can plan, the easier the transition should be, including avoiding being able to work on site and so time starting to run on the programme and costs being incurred, but no physical work is possible because of resourcing issues or supplies. When a restart is possible, either because the government guidance has been relaxed or a site-specific risk assessment has identified work that can be done safely, a timetable should be set down for actions leading to the first day on site. This may have to be drawn up in advance as to be instigated when you get the notice, as in reality, there may not be much time between the notice or instruction to resume and the date for resumption. Once the green light is given, the site survey carried out on demobilising should be reviewed and a new one carried out to see if there are any changes. This will allow you to accurately plot work still required so that programmes can be updated and key initial tasks can be identified that may assist in getting the site going and or to accelerate the programme. While it would be useful if that survey could be done before remobilisation, we appreciate that this may not be the case, and so it should be done as early as possible once you're on site. Once this survey is done and people are back on site, it will allow you to give the project team an accurate picture of the works done and to be done. This will avoid confusion and also emphasise that with collaboration, the original aims and the objectives of the project can be met and the impact of COVID-19 can be reduced as much as possible. The site survey should also allow programmes to be updated to reflect the impact the shutdown has had. Those programmes should be submitted as necessary under your contract, as Madeleine has just discussed. However, we do not expect work to revert to a pre-COVID-19 situation, and there will be need to be monitoring of any continuing impact the pandemic has, whether that be social distancing, resourcing, materials, or other matters that impact delivery. It will also be necessary to engage your site operatives and project management team to be able to restart on that first day. Some staff may have been furloughed. Once they restart work, that furlough period is over and the employer becomes responsible for their pay in full. Consideration will have to be given to any minimum time periods for a furloughed worker, which is usually 3 weeks. If that period has not been reached, then there is the potential for a lag before they can recommence their duties. This will also apply to subcontractors and the design and consultants team. In particular, those trades carrying out the next key tasks should be fully briefed of the timetable, and insurance should be sought that they can remobilise and provide the staff required on that first day, as well as have supplies in place. As with your own contract, consideration will need to be given as to entitlements your subcontractors will have on remobilisation costs, and this should be factored into your overall cost of remobilisation. In terms of getting people back to site, there may be the need for some flexibility. If all relevant parties are engaged early enough in the restart process, the timetable should allow for this flexibility. Sites cannot be expected to go from dormant to 100% pre-COVID-19 levels of operation overnight. As I mentioned earlier, it will be vitally important to engage with your supply chain. And this should have just been continuing through the shutdown to try and maximise the amount of material that can be delivered to site, as long as it can also be safely stored. This is reflected in the CRC's identification that material shortages pose a significant risk on future construction projects. Even items that are normally readily available may suffer from delays to the normal time frame, being order and delivery to site, as everyone will look to kick on with their works once restrictions are lifted and more sites are deemed safe to reopen. Such delays and an unavailability of materials will impact on programme. As such, you should identify the key materials needed to restart and place orders now to overcome future delays and work with your supply chain to maintain deliveries. It will also be prudent to get an understanding from them about the stock they hold and how they are planning to obtain stock from third-party suppliers, including from abroad, given some restrictions on import and export. It may also be considered necessary to work with the project team to identify alternative materials that may be easier to source. However, care will be needed if such materials are outside the specification, and so agreements will need to be reached that the specification can be altered. Proof that the overall quality will not be diminished and the project is as safe as that required by the specification is more than likely to be needed. In addition, any impact on cost of the higher demand of materials, which may cause price rises, or the cost of alternative products that are readily available, will need to be taken into account, and where necessary, applications for variations or instructions to sanction the higher costs should be made so that they are recoverable. An additional external factor that will need to be addressed is the availability of any plant to be hired, whether for the first time or being returned from before the close down. Demand for such plant may be high, and again, prices may have gone up to that budgeted for at the start of the project. Your contractual right to any further payment upstream or ability to resist any price increase due to existing hire arrangements will need to be considered and any necessary notices issued. Some projects, particularly infrastructure projects, require specific permissions and approvals to carry out certain elements of the works. This may involve road or rail network closures, access to third-party land, or cutting off utilities. In addition, some work items are dependent on third parties, such as statutory undertakers, carrying out works in advance, which would typically be diarised weeks, sometimes months ahead of schedule. Such permissions and attendances will be need to sort again to reflect the updated programme. It is unlikely to be as simple as deferring it for the same period of time as the site was closed for. Early identification of the necessary permissions and attendances will enable you to be proactive in your resubmissions and discussions, such that any impact on the projected programme once work restarts is minimised as far as possible. Advice should also be sought as to any contractual entitlements for additional time and/or money if works are delayed because of a third party. In addition to these measures, it must be appreciated that some form of social distancing may still be in place. As such, safe site operating procedures should also remain in place, and information related to site operatives to avoid the risk of a return to the current restrictions. We expect that the CLC and Beale Co will continue to produce updated site operating procedures to reflect the latest government advice. Those social distancing and safe site operating procedures should also include policies in place in case any staff members come down with Covid-19 symptoms after reopening. And I think which will become standard is appropriate hygiene stations and PPE equipment will be spread around the site, probably in a higher proportion than before the pandemic started. A final potential impact of the social restrictions is a shift to more remote working, utilising available technology to carry out work and to maintain contact. These remote working practices may need to factor in to ongoing project roles. It may reduce meetings on site, but it will need clear leadership so that the key issues are still addressed and that the appropriate management resource is factored into any price for future jobs. So to conclude our views on the current position and future steps that should be taken, obviously the position does remain fluid. All eyes are on the government with regard to when the current guidance for social interaction and distancing will be relaxed, and if so, to what degree. In the meantime, construction work should only be carried out if your project-specific risk assessment shows that you can comply with the government and industry guidance for safe working and your employees are not put at risk. Your contracts remain integral to the future operation of your projects, both for those where the site is closed and works are suspended, or where works are continuing, even if subject to some adjustment. For those where there is a suspension in place, by way of the contractual notices, ensure the further notices related to the suspension, payment and delay are issued to safeguard your position on time and money, and cut off any potential for future claims by the employer. Where there is an agreement to stop work but no contractual notices have been issued, check whether a formal suspension can be issued retrospectively. If not, seek to do a deal with your employer such that you safeguard your position on time and money and protect against any claims against you. From a practical point of view, in both these scenarios, keep in contact with the project team and supply chain so that what can continue does, and that when sites reopen, generally or following a specific risk assessment, works can get up to speed quickly. If you are continuing on site, your first priority must be health and safety. Do you have any concerns about the health and safety position? If measures to contain COVID-19 are not possible to implement on the site, or the type of work being carried out alters from your original risk assessment, such that the government guidance cannot be followed, then you should stop work, issuing the appropriate notices. If your risk assessments show there is no immediate need to stop work in accordance with government and industry guidelines, then you may consider it sensible to continue working, provided that you do in fact follow those guidelines. We would strongly advise that risk assessments are recorded with specific reference to the guidance requirements and how those requirements are being addressed on site, including the briefings to the site operatives. You should work with your supply chain, who may be subject to different restrictions that could impact on their ability to provide you with materials. And you should consider the impact on program and costs of any alterations made to working practices because of COVID-19. Fundamentally, the position must be to stay as safe as possible and assist in restricting any further spread of COVID-19. That draws us to the end of this webinar. I hope you found it useful. We would of course be very pleased to discuss anything that we have covered today, or to discuss further any particular issues or concerns you may have in relation to projects, whether that be project advisory or disputes. We've slightly run over and we haven't been able to address any specific questions put to us, but we will look to get back to you. This webinar is part of a series of webinars that we at Beale Co have been hosting and will continue to host in relation to COVID-19. Those will be published on our website and the details are on this slide. And we are also producing articles, and again, the link is there for you. Please keep in touch with us and so you can find out about those webinars. Now, if you do need support on COVID-19 or other project-specific issues, you may be interested in our in-house lawyer service. This virtual service provides you with an access to any member of our contracts and projects advisory team, as if you had an in-house counsel helping you on your projects. This advice is commercial, frank and direct, and rapid. The rate card involves a significantly discounted hourly rate compared to our standard hourly rates, with much flexibility over a period of a retainer. Details are on this slide, and please do not hesitate to contact us if the in-house lawyer service might be of interest. Finally, thank you for joining me and Madeleine this afternoon. Keep well and stay safe.